So first and foremost, it's really important that Maine citizens understand the process. Under Maine law, if I qualify any candidate for a ballot, for a primary ballot, any registered voter in the state of Maine may challenge the qualifications of that candidate. And that's what happened here.
Secretary of State Shanna Bellows is talking about her 36-page decision barring former President Trump from appearing on the Maine GOP primary ballot. Maine is different from other states like Colorado and Michigan, which both faced similar challenges. Before a challenger goes before a judge in Maine, they first have to face an administrative hearing with the Secretary of State.
I was required by the law to hold a hearing, an administrative hearing on those challenges, where both sides could present evidence, witnesses, engage in cross-examination, and argument.
That hearing was held on December 15th. Originally, Secretary Bellows was supposed to release her decision on December 22nd, but the windstorm and decision from the Colorado Supreme Court delayed that until Thursday, when she ruled that Donald Trump did engage in an insurrection on January 6, 2021.
But this hearing was different. I recognize it's unprecedented for a Secretary of State to deprive a presidential candidate of ballot access due to Section 3 of the 14th Amendment. But it's also unprecedented for a presidential candidate to have engaged in insurrection, which is explicitly prohibited by Section 3 of the 14th Amendment.
In the days leading up to her decision, Secretary Bellows was asked to recuse herself by lawyers for the former president, citing old social media posts saying she couldn't be unbiased in her decision. Bellows disagrees.
My political affiliation and personal views of January 6 did not enter into this decision. Under Maine law and the Constitution, my obligation was to review the evidence, the facts, the law, and the Constitution, and make a decision based on the record from that hearing.
Bellows' decision isn't the end. The decision can now be appealed within 5 days to the Kennebec Superior Court. Bellows has suspended her decision pending the results of those appeals, but the clock is ticking. While Maine's primary isn't until March 5th, ballots need to be printed and ready to be shipped out well before then.
Under federal law, our military and overseas voters, sometimes called Yokava voters, they are authorized to receive their ballots 45 days prior to an election. Our election is March 5th. That places that 45-day deadline at January 20th.
Under Maine law, the Superior Court would have to issue a ruling no later than January 17th. Bellows says she will respect the outcome of any appeals. To read Bellows' full decision, you can head to our website. In Augusta, I'm Corey Bouchard for ABC7 and Fox 22 News.